So hello everybody and welcome to today's episode of Activist Lawyer. Today's recording features Marc Willers KC from Garden Court Chambers. Now Marc was on a working visit to the north and I was delighted that he could join me in the studio in Newry to talk about his practice, which is predominantly human rights based, focusing on traveller and gypsy law as well as environmental law and climate justice cases. He recently had huge success with the Klima Signorennen, if I can say that correctly, versus Switzerland, which some of you might be familiar with. He talks about that, as well as a recent victory on a climate justice case that he was acting in. And the decision in that matter was delivered on the very day he joined me in the studio. So stay tuned for more on that. I hope you enjoy today's episode. Hello, Marc.
Hi, Sarah. It's great to be here.
Thank you for joining us. It was a little bit of a journey to our studio in Newry. How are you finding Newry so far?
Well, apart from the bomb scare,
I
was delighted to see Pat Jennings' statue outside the offices. He's a childhood hero of mine, being a very keen Spurs fan.
Excellent. Well, that was one highlight. And we'll skip over the slightly sinister bomb scare that came in. But nonetheless, it's fantastic to have you here. I know you're here in the north for a few visits. You're going to be meeting with some of your colleagues. So it's fantastic to have you in our studio to talk about some of your work. And I think we'll get into it. The first question, I suppose, what we ask with all of our guests is around your legal journey and what inspired you to do law in the first place?
Well, it's a combination of factors, really. I mean, there was a chance that I'd become a builder as opposed to a barrister. Because my family, or at least my father's family, are builders and undertakers. Oh. So I was tempted to go down that route. But my father was a barrister. He left the building trade to become a barrister, and I followed him, really, without necessarily thinking too much about it, apart from the fact that I didn't want to be on a shovel or a cement mixer for the rest of my life.
Fair enough. And then the particular areas that you're working in, was that something you'd planned, or did you fall into the areas of practice and kind of a human rights-based centred approach to your practice? Yeah,
no, I when I first became a barrister, I think I was quite naive, and I didn't really understand the extent to which many vulnerable groups, suffer from discrimination and inequality of opportunity. In fact, I did a lot of criminal work at the beginning of my practice, and was slowly but surely introduced to Gypsy and Traveller Law, representing Gypsy and Traveller families who are trying to seek planning permission for their caravan sites. Mm-hmm. And being introduced to those families, getting to know them, getting to understand their particular difficulties in terms of their accommodation needs not being addressed by the state, led me into other areas where they also suffer from discrimination, not least trying to access goods and services. Yeah. And more widely, the endemic discrimination they face from the settled community, which is then reflected in policy and legislation, which is handed down by, the governments both in the UK and in Ireland. And so as I became more attuned to that, as I became more, I suppose, as I recognise that existence of the last bastion of racism, really, as it's been described, I thought that I should do something about it. Mm-hmm. So I took on those discrimination cases too, took cases to the European Court of Human Rights, and back in the UK, any number of cases before the High Court and Court of Appeal.
And of course, you're pretty much a specialist in that area of the law, having co-edited Gypsy and Traveller Law and the editor of the Council of Europe's Handbook for Lawyers Defending Roma and Travellers. And I think that's entitled Ensuring Access to Rights for Roma and Travellers, the Role of the European Court of Human Rights. So as mentioned there, you touched on discrimination against travellers and gypsy communities, and it is widespread. And I mean, in Ireland, it's very much a problem. It's often unseen, and it's certainly, for the most part, I feel, and maybe I'm wrong, it would go unchallenged. Why do you think this is? And maybe the UK is a little bit more advanced in that. But what is affecting, people taking cases or getting involved in challenging this particular type of discrimination? And also what matters maybe are arising that you see that could also be reflected in society here that you're being instructed on?
Sure. Well, the first point is that discrimination against Gypsies and Travellers is endemic. They are the most discriminated communities within society, whether it be in the UK or in Ireland. And so that discrimination, that prejudice pervades each and every area of our society, including the legal profession. So there aren't that many lawyers who will take on cases for Gypsies and Travellers, whether that be in the UK or in Ireland. Indeed, I've been involved in a project down in Cork to try and encourage lawyers to take on cases before the Work Relations Committee and in the District Court, challenging discrimination on behalf of Irish travellers. And it's been very difficult to encourage them to do so.
Yeah.
But the same applies in the UK. There are very few solicitors, very few barristers that will work with Gypsies and Travellers. And I think a lot of that stems from the prejudice that the wider community holds against those vulnerable groups. Yeah. So that's the starting point. And then we find that not every judge that we come in front of is sympathetic to the upholding the rights of Gypsies and Travellers. It's changing a little now, and I find that the more I bring cases before judges, the more that I'm able to educate them about the discrimination that my clients face, the more they are willing to put in their judgments positive points, which then lead other judges in the future to follow those precedents and give judgments which, end up improving the rights of Gypsies and Travellers. So it's a very slow process, and something of a rocky road. But we are finding that there are occasions when we're making a real difference for everybody, perhaps by challenging legislation like the Police Crime Sentencing and Courts Act, which restricted the ability of Gypsies and Travellers to camp on the roadside to an even greater extent than they are already denied that right. And also in a case that I did involving a policy definition of what it means to be a Gypsy or Traveller, which excluded all those who were too old or too ill to travel for work, discriminating against the elderly and the disabled. Okay. And the Court of Appeal upheld that challenge and the policy definition, which is needed by Gypsies and Travellers if they want to obtain planning permission for a caravan site, has been widened to enable those who are too ill and too old to travel to come within that definition. So there is, we do see through litigation small steps to being taken to undermine or to the prejudice that Gypsies and Travellers face, and occasionally improve their rights and their ability to access goods and services.
That's positive, And I suppose it's important that clients feel comfortable and emboldened to take those cases forward, because it's not always easy, and very often it's easier just to accept, what discrimination they've faced and move on, because sometimes it can be daily, which is really difficult to hear. I know in Ireland, the Supreme Court had recently overturned a High Court decision which involved a family who were evicted from council property. And it just struck me, it was Mr. Justice Gerard Hogan who said the recognition of travellers as a vulnerable minority by the court is also hugely significant, as it places a particular duty on the courts to take into account their circumstances when faced with an application to have them effectively evicted from an authorised site. So it seems to be almost this a way to balance the rights of that group in line with international mechanisms, as well as the European Convention on Human Rights, and then the obligations of, let's say in Ireland, for example, the local authority or the council who have the responsibilities to house them. Is that really what we're seeing when it comes to a deliberation of these decisions?
Yes, I mean, very, very much so. I think that the European Convention on Human Rights is a valuable tool that we as representatives of Gypsy and Traveller people can use to protect and further their rights before the courts. And the European Court of Human Rights has accepted that there is a positive obligation to facilitate the traditional way of life of Gypsies and Travellers. And part of that, an integral part of that way of life, is living in caravans. And not every Gypsy and Traveller lives in a caravan or indeed wants to live in a caravan, but those that do should have the right to respect to do so without undue interference. That doesn't mean to say they're entitled to planning permission wherever they want to station their caravan and wherever they want to set up home. But there should be, on the state's part, and there is an obligation to facilitate that way of life by providing locations where they can do just that. And unfortunately in the UK, particularly in England and Wales, we find that local authorities are failing in that duty, pandering to the prejudice of the electorate, many of whom don't want to live next door to a Gypsy or Traveller site. And that means that Gypsies and Travellers who continue to live in caravans and want to live in caravans are forced onto the roadside, are continually evicted, and so they're on effectively a road to nowhere, being pushed, from pillar to post, and that exacerbates the inequalities they face. So, being moved around like that means that they can't access education for their children. Healthcare suffers tremendously, and on top of that, they're forced into what is a transitory form of work, if they can get any work at all. So they can't take on the kind of jobs that you or I would want to take on. Their children can't get their education so they can improve themselves and perhaps take on sedentary work. And indeed, even if they do take on sedentary work, when it comes to applying for planning permission, we have this idea that you need to be able to travel for an economic purpose in order to satisfy the planning definition. So that in itself is a bit of social engineering, which is really inappropriate and needs to be done away with. That might be the next case.
And aside from the challenges around accommodation, I have noticed across Ireland and the UK, maybe, I don't know if a rise is the right word, but a number of successful cases brought by travellers who face discrimination at the hands of usually hospitality, the hospitality sector. Is this something that you deal with or that you've seen being brought forward more often? And it's great to see that they are successful in those cases that highlighted the appalling practices, quite frankly, of some of these restaurants or hotel chains, whatever it might be.
Yes, it's certainly an appalling practice, and it's one that has been successfully challenged in the courts on a number of occasions. Perhaps the most well-known example was the case I did involving an incident that occurred at a Wetherspoons pub in North London. And I'll tell you the story very briefly.
Yeah, sure.
But what happened was that there was a conference at the Traveller Movement's offices in the Holloway Road. And at the end of the conference, and this was a conference attended by a couple of hundred people, there were people from all walks of life. There were people from NGOs that work with Gypsies and Travellers. There were people from the church, educationalists, police officers, doctors, healthcare workers. And at the end of that conference, the chair, Father Joe Brown, invited everybody to the Coronet pub, which is literally located next door to the conference venue, so that they could socialise and network. Everybody, or a number of people, took up the offer, and when they got to the pub, they found that they were confronted by two very large bouncers who said to the people at the front of the queue, "You're not coming in, you've been to the Traveller conference."
Okay.
And so they were barred from entering the pub. Now, at the front of the queue, there was an Irish traveller, there was a Romany gypsy, there was a police inspector with his lanyard.
Okay.
There was a solicitor, Martin Howe, who is on the board of Liberty, and also Father Joe Brown. And so these were the first 5 people in the queue, And although it might sound like a joke, it really wasn't a joke, because these people were being clearly discriminated against because of their association with the Traveller Movement's conference. And what had happened was that a few days before the conference, a customer in the pub had been reading the Irish Times, had seen a reference to this conference and the fact that it was going to be talking about Dale Farm. And Dale Farm was another case I was involved in, where there was a massive eviction of Irish travellers for no really good reason from land that they owned. And so the publican, it seems, decided for himself that if there was to be a conference about Dale Farm where travellers might attend, they may then come to the pub, and because they're travellers, stereotypically, he thought, they would cause trouble. So he put the bouncers on the door, and those bouncers then barred the people from coming into the pub. This being a pub which is regularly hosting huge crowds of football fans on a Saturday attending the Highbury Stadium to watch their team play football. So not a pub that was unused to big crowds of people who might possibly be resorting to violence, but it was considered sufficient in this case, sufficiently risky by the publican, jumping to the stereotypical conclusion that travellers cause trouble, particularly when they're drunk, that led him to put the bouncers on the door and to bar the delegates from attending. And so the Traveller Movement, who hosted the conference, and a number of the gypsies and travellers, Martin Howe, the Father Joe Brown, and the police inspector, sued Wetherspoons. Good. And after a 3 or 4 week trial, and it took that long to convince the judge and get through the evidence.
Wow.
The conclusion of the judge was that Wetherspoons had discriminated against all of the individuals and also the Traveller Movement. And that case has been held up as a precedent and used time and again in cases where travellers have subsequently been discriminated against and resulted in many settlements.
Yes.
Whether it's going to change practice when it's not challenged is another matter.
I mean, that's the thing, whether it's going to be challenged. But it is good to see. I don't think, looking back maybe 20 years ago, you would have even seen the cases being brought as much as they are now, or the same decisions. But as you said, there's some slow move there, and litigation is pushing matters forward along with activism, which we'll talk about in a little while. But just in terms of your other work, Marc, that we will take a look at, you are involved on many at the moment currently and over the last number of years, high profile cases around climate justice and environmental law. And recently, you most notably acted on, then I hope I get this right, Klimasenjorinnen versus Switzerland, which was the first ever climate change case to be decided by the European Court of Human Rights. Can you tell us a little bit more about this action, how it came about, and also what the significance is of this judgment, which has been described as groundbreaking? Sure.
Well, the Klimasenjorinnen case has to be the highlight of my career so far. I was privileged enough to be one of the lawyers representing the, and we'll call them the Swiss Senior Women's Association, the Klimasenjorinnen, before the European Court of Human Rights, as you say, in the first ever climate justice case that it considered. The association itself consisted of over 2,000 women, all over the age of 65, I think with an average age of 73, who had complained to the Swiss authorities and took their complaint through the Swiss courts about the failure of the Swiss government to tackle climate change, to take sufficient steps to tackle climate change. Their complaint had not been properly addressed by the courts in Switzerland. The courts considered it not to be justiciable. And so they took their case then to Strasbourg, to the European Court of Human Rights, and I was drafted in with another KC, Jessica Seymour KC, to make the oral submissions before the European Court. And we did that in March of last year. The hearing was before the Grand Chamber, so we had 21 judges file into the court. I think there were 17 judges dedicated to hear the case and 4 substitute judges in case any of them dropped out or left their office in the meantime. The arguments were short because we only have a limited time to make our oral presentations, having made a lot of the presentations in writing. But essentially, the women, 4 individuals from the association and the association itself, argued that the failure on the part of Switzerland to take adequate steps to assess what carbon budget it had left to use up, and how that would be used up, and how they would get to net zero by 2050 in accordance with pledges that had been made under the Paris Agreement signed in 2015 by Switzerland, breached their rights protected by Article 2 of the Convention, the right to life, Article 8 of the Convention, the right to physical integrity, and also the failure of the Swiss courts to address their complaint breached their rights protected by Article 6, the right to a fair trial, and Article 13, the right to an effective remedy. So these arguments were put before the European Court of Human Rights. The Swiss government argued that, again, the court should not interfere. These issues were not justiciable. And the court a year later came back with a momentous judgment concluding that rights protected by Article 8 of the Convention and Article 6 of the Convention had been breached, in that the Swiss government had failed abysmally to assess what it needed to do to reduce its emissions by 2050 in accordance with the pledges it had made in the Paris Agreement, and that the Swiss courts themselves had then failed to tackle the Swiss government's policy failures. And so a breach of Article 8 and a breach of Article 6 were found by the European Court of Human Rights. The decision was a majority decision. There were 16 judges that found for the Swiss Senior Women's Association. One judge dissented. That was the British judge, Judge Marc KC. And he considered that the European Court of Human Rights didn't need to go as far as to find that there had been an Article 8 breach, that it could limit itself to a conclusion that the Swiss courts had failed to properly grapple with the issue, and that they should be tasked with going back to, with the case being taken back to them, and the court, the Swiss courts, then reconsidering the matter. I think that would have been a recipe for delay.
Yeah.
And the reality is that the judgment itself, although it sends out a signal to the Swiss government that it needs to take further steps, also makes it clear that any other court in the Council of Europe, 46 member states area, that fails to do that will also be likely to suffer a similar judgment.
Brilliant. Well, congratulations to you and your team and everybody involved in that. And of course, those women for taking that case. They're fantastic. And it's really, although there's a sense of urgency about this type of action, it's a very exciting time for environmental law and taking actions under climate justice, in terms of climate justice issues that are arising. We're seeing more and more young people not only becoming involved as activists and campaigners across the world, but also taking action themselves. Similarly to that case, there are quite a few examples either that have just been heard or else that are ongoing, where young people are bringing actions and are relying on international mechanisms and the ECHR to protect their rights. Why do you think we're seeing more of this, and how receptive are judges to these actions being brought by younger people?
Well, I think we're seeing young people at the vanguard of the climate litigation that is before the courts, because the climate emergency is going to affect them the most. And, people of my generation won't be around to see the worst effects of climate change. And I think also young people and children are looking at politicians and their failure to tackle climate change, their failure to adopt policies and enact legislation that will do that job effectively within a short period of time. And we need to act urgently, particularly within this decade. And being frustrated by what they see of their elders' failure to live up to those responsibilities, they are turning to litigation wherever they can, and those who will support them in bringing litigation and bringing their case before the courts. And judges are becoming more receptive to the arguments. Not all of them, not every judge that I've been in front of and argued these points necessarily understands the significance and the impact that climate change will have on children and indeed future generations. But the Klima Signorinen judgment is an example of a case where 16, perhaps even 17, because I don't think Judge Ike disagreed with the findings on the science, accepted that there is a real issue of intergenerational inequity arising from climate change, and that there needs to be a process whereby judges now take account of the impact that climate change will have on children and future generations when deciding cases brought by children and other and people from other generations challenging states in inactivity or a failure to tackle climate change. So I think that you may be aware that there were 6 Portuguese young people who brought a case alongside the Klima Signorinen case. Their case was called Agostinho, and they challenged not just the Portuguese state, but also 32 other member states of the Council of Europe for failing to tackle climate change. And their case was dismissed on the basis that it didn't jump the hurdles, the admissibility hurdles that the court sets for every case. However, when giving judgment in the Klima Signorinen case, we can see that the court had taken account of a lot of the arguments that were advanced by the children in the Agostinho case. And so, although the children came away disappointed that their case had been dismissed, that it hadn't been ruled admissible, the reality is that I think that the fact that they brought their case and argued those intergenerational points and made the court clearly aware of the impact that climate change would have on children and future generations influenced the judgment in the Klima Signorinen case. So there's an example of children and young people, bringing a case which I think has moved the dial as far as the court is concerned and the protection of their rights is concerned, not just now in Strasbourg, but in every case that would be brought in the national courts in the 46 member states. But there have been other cases where young people's rights have been heavily influential in decision-making in apex courts around Europe. There was a case called Neubauer, I think, or Neubauer, the German case, where, again, the court was very concerned about the impact of climate change on children and future generations. And there is litigation going on in the US in a case called Juliana against the US, brought by 21 young people, assisted by an organisation called Our Children Trust, where they are suing the US president for failing to tackle climate change on constitutional grounds and public trust doctrine grounds. And again, whether or not that case is ultimately heard, and there's a lot of hurdles that the children have had to go through in order to get their case heard. The fact is that they are highlighting the issue in such a way that it's almost impossible now for the states, the states, but also the federal government to ignore.
To ignore it. That's the elephant in the room, I guess, as well.
Every time.
Yeah, and it's global. I mean, it's just so fascinating to see. And there have been, Australia is another example where I think there were 8 young children who challenged a brand new coal project that was being proposed by the Minister for the Environment, and they were successful in that matter. So it's really great to see movement there. And as you said, even if they're not successful for whatever reason, it's raising huge awareness to that matter. And just before we recorded today and come into our studio, you were working on sharing some news of your own on a case that you were working on with the Wheeled Action Group, Finch.
Yes, it's a case called Finch against Surrey County Council. Yeah. So this morning, the Supreme Court in the UK, in London, sitting in London, handed down judgment in a case called Finch against Surrey County Council. And that was a case where our client, Sarah Finch, supported by the Wheeled Action Group, had challenged a decision taken by Surrey County Council to grant planning permission for oil production in the Surrey Hills, so near Gatwick.
Right.
Surprising that there would be oil there, or an oil production platform, but there we are. And Surrey County Council had granted permission for the oil wells to be drilled for a period of 20 years. So well after the time when really we should be moving well away from any type of fossil fuel production. And in doing so, Surrey County Council hadn't taken account of the downstream emissions that would be likely to be likely to be caused as a result of burning the oil that was to be produced. And Sarah Finch argued through the courts that it was imperative, indeed a requirement of the Environmental Impact Assessment Directive, an EU directive that is still applicable in the UK and is certainly applicable in other countries in Europe, a requirement that downstream emissions should be taken into account by the decision maker as an indirect effect of the project. In the High Court, that argument was roundly rejected, so too in the Court of Appeal. And she then took the case, or we then took the case for her, to the Supreme Court. And by a majority of 3-2 judges today, the court ruled in her favour, which is fantastic news.
It's huge.
And the decision now will obviously have an impact on many cases that have been backed up and been adjourned pending the outcome of this case, but also on each and every decision taken by a planning authority in the UK where they have to consider the grant of planning permission for fossil fuel development, whether that be oil, gas or coal, including the drilling of oil out in the North Sea and elsewhere. On top of that, I think that the decision of the Supreme Court will have something of a precedent effect around the whole of Europe, where the EIA directive is applicable and beyond, because judgments of the Supreme Court are given an incredible amount of weight in other jurisdictions globally. So I really do think that it will have a global effect, but also if you think about a decision maker, perhaps it's sitting in a council committee room, being told exactly what the impact on global warming at a time when we're in a dire climate emergency, the impact that the grant of planning permission will have as a result of the inevitable greenhouse gas emissions that will arise from the burning of the fossil fuel, then you might be forgiven for thinking that many, perhaps most decision makers will think twice, perhaps come to an inevitable conclusion themselves that planning permission ought to be denied.
Right, okay.
And so, I think the decision could have a massive impact on fossil fuel development in the future.
Wow, it's so interesting to see the knock-on effect potentially of that. And am I right with when you practiced climate justice and environmental law, there's a real international element to it that might not necessarily exist with other areas of human rights law. For example, I mean, a decision on immigration in Australia might have little to no bearing on what happens here, for example, but an environmental law decision or action potentially could, even if it's outside the remit of the EU, because of the global kind of summits that are in place in each country, I suppose, watching what the other one is doing, and there's joint responsibilities there. Is that a fair enough assessment? It kind of goes hand in hand to understand that international.
Yes, it is. I don't want to underplay, the benefits of comparative legal knowledge in other areas, but I think because climate justice is a relatively novel area, judges are very concerned about going too far and perhaps creating precedents which may have implications which they hadn't considered. And if you go back to the Klima Signorinen judgment, we can see that Judge Tim Ike was concerned about perhaps the implications of the judgment of the majority, creating unforeseen consequences. I think that the Klima Signorinen majority judgment will actually give other judges in other jurisdictions confidence to take the necessary steps and engage with. Indeed, the court has said they should be under a duty to grapple with arguments rather than avoid them and conclude that they're not justiciable. In the Finch case, we relied on comparative law decisions from Australia, from the US, from Germany, from the Netherlands, where the landmark agenda case was decided. That was a decision of an apex court, the Supreme Court, the Dutch Supreme Court. And we were able to say to the European Court of Human Rights, look, there have already been judges who have interpreted your Strasbourg jurisprudence and come to the conclusion that it is engaged by the state, in its policy making regarding climate change, because those policies have an impact on the lives and physical integrity of their citizens. So we were able to give the European Court of Human Rights judges the confidence to take the necessary steps. And they did just that. And they went further than perhaps the Dutch Supreme Court had gone. But I think that each and every decision which is positive and recognises the science behind climate change and understands the impact that it will have upon the citizens of particular countries, such as the impact on the elderly Swiss women of the intense heat waves that Switzerland's currently facing every year. The more that these cases are decided, the more confidence a judge will have to go the same way. So I think we're dealing with a relatively novel area of law, and judges who are having to learn, as I've had to learn, about the issues, understand the science, and seeing it written down clearly by judges in apex courts like the Supreme Court and the European Court of Human Rights will make our lives, as barristers arguing the point, so much easier.
Wow, yeah, fascinating. And it is an emerging area of the law, as you said, environmental law, climate justice. More and more young people are maybe thinking about getting involved in that, as well as when we touched there on your work and your advocacy for traveller and gypsy communities in the UK. There's a need, we've mentioned, for more solicitors and more legal representatives to come on board in that work. If anyone's listening today and would like to get involved in either of those two areas or both, or the other work that you do as well, which of course we, your civil liberties and human rights work in general, what advice would you have for anybody who is thinking of getting involved?
Well, I think that it's really important to understand the topics that you're interested in as best you can by, checking out what there is online, what there is in book form that would give you a better understanding of the areas. I'm going to give a plug to a book that you've already mentioned, Gypsy and Traveller Law,
yes.
Published last, I think, in 2020, if memory serves correct, and already slightly out of date, I hasten to add, because we've had a couple of good decisions since then. But that book was published by the Legal Action Group, and the Legal Action Group itself, based in London, it also publishes monthly magazines which keep lawyers in the kind of work that I do, social welfare, civil liberties, environmental and human rights, and Gypsy and Traveller Law up to date with the law in great detail. And so I would recommend that people subscribe to that magazine, giving them a plug. As our publishers of the book, perhaps buy the book or rent it out from a local library. That will give you a really good understanding of many, if not all, of the issues that face gypsies and travellers, certainly in the UK. And in fact, much of what we say in the book is equally applicable, perhaps by analogy, if nothing else, to the position of travellers in Ireland, because very many of the same issues arise, and indeed the European Convention case law that we refer to and document is equally applicable. But I think that one thing that worked for me and has really helped me understand the issues that gypsies and travellers face is working with NGOs. So getting involved with your local NGO that supports gypsies and travellers. In the UK, I'm a trustee of Friends, Families and Travellers, which is a national organisation, but I work with the Traveller Movement, with London Gypsy Travellers and various other NGOs. And, just visiting their websites, you'll learn a huge amount of information, because they have vast resources that you can easily download and tap into without spending a penny. And then perhaps contacting them and offering to act as a volunteer, or even just indicating that you're interested in assisting in any way you can. And once people get to know those who are working with gypsies and travellers, and then are introduced to gypsies and travellers, and then start talking to them about the issues they face, a whole myriad of matters are likely to be disclosed, and it becomes much easier to understand the discrimination they face, and perhaps how it can be tackled. There are some solicitors who are particularly specialist in working with gypsies and travellers, and again, it's worthwhile getting to know them, even just to introduce yourself as somebody who's interested in working with gypsies and travellers, and so by making that first step, and there may be some hesitance, there may be some worry that perhaps there may be some failure to understand or appreciate cultural norms and so forth, and that might be a bit tricky, but breaking the ice, really gets one into the position where one can take on the cases. Now, climate justice is similar in the sense that, albeit different NGOs are involved, like Greenpeace, Friends of the Earth, Northern Ireland, and so forth. But again, I think it's important to understand the landscape, the NGO landscape. Follow those on Twitter, I think we still refer to it as, and on other social media platforms. Get a real understanding of the issues. It might be climate justice, it might be sewage pollution, it might be forever chemicals. There are all manner, I'm afraid, of issues that need to be addressed. And again, download so much information out there. It's not true.
Yeah,
but
there's a lot happening at the minute on it. So
download some of the cases which really do summarise, the law and the science, and get familiar with the issues, and then make the connection with those that you're following, or perhaps with solicitors who are working in the field. There are 4 or 5 excellent firms out there in England and some in Northern Ireland too, that would certainly be, I'm sure, very keen to speak and just give some guidance as to how to go about getting involved in these cases. So I would not be I wouldn't be too hesitant about making those approaches.
Yeah,
you can only be told no.
Exactly, you've nothing to lose, and there's so many opportunities there. Given that, particularly with environmental law and climate justice, as you mentioned, there's a whole range of issues separately that you could tackle, and there's so much in terms of resources out there that wouldn't have been there many years ago. So
exactly, and there are local associations and organisations that are fighting individual cases. The Wheeled Action Group is a good example, working to support Sarah Finch, our client, in the Supreme Court judgment handed down today. And then on top of that, I think that the other thing to say is this: that if one's studying law, and it doesn't have to be law, but studying at universities, there are a lot of law clinics within universities where they are doing great work, climate work, trying to assisting local associations and activists to take on cases, or to understand how to take on those cases. There are also law clinics that are working with Gypsies and Travellers and Roma in and around the UK. And again, if you're a student at a university with a law clinic, then I definitely suggest getting involved.
That's fantastic advice. And in Ireland, I think as well, they had the Free Legal Advice Centre, and there are a few in Galway as well, if I recall from my day there. But it's really important to seek out that kind of clinical legal education approach, which universities seem to be latching onto a little bit more than back in my day when it was the textbook and you get on with it. So that's fantastic and really great practical advice there. And just, Marc, finally, and I'm interested in your answer on this, about activism and the law, in terms of activism and the law working together to make real and meaningful change. And I'm only thinking you've hundreds of examples of your work, but what are your thoughts on that?
I think activism is so important if we're to make significant change, whether it be before the courts or in Parliament. And courts can and judges can make a difference, but ultimately we need to get the politicians to change their behaviour in climate justice cases. We try and convince judges that the government of the day hasn't taken necessary steps to tackle climate change, and we've been lucky enough to find, particularly in the Klima-Signorin case, that the European Court agreed with us in the case of the Swiss government's failings. But ultimately, I think activists are likely to convince the electorate to send a message to the politicians who are responsible for adopting policy and legislation which will do the job of tackling climate change. And it's really important that they are given the space to make the case, and that case is effectively communicated and gets through to the electorate, because if we can vote out those that are failing to tackle climate change, failing to protect the rights of children and future generations, then we will get to our goal of achieving net zero, but going perhaps further than that, and significantly mitigating or reducing the harm that is being caused by global warming. And so activism outside of the courts is going to be crucial. It can work very well with litigation and the inspirational Swiss senior women, just highlighted how good, the campaign around a case can be. We were lucky enough to win the case as well. But even if we had lost it, I think the amazing work they did to highlight the issues in their case must have galvanized a huge amount of not just women, but men, but also not just elderly, but younger generations to bring cases before their courts. And that was part of the objective. But we achieved not just that objective, but also a resounding result before the European Court of Human Rights. And there have been instances where climate litigation has failed before the courts, but nevertheless, the very fact that the litigation has been brought has made a real difference, not just in highlighting the issue, but also in changing minds in government. And I'm just thinking of one case, the People's Climate case before the Court of Justice of the EU, where in that case the complainants argued that the EU had failed to adopt a sufficient greenhouse gas emissions reduction target. Their case failed on admissibility grounds, but the EU increased the reductions target, and pretty much as a consequence of that litigation being brought. So in the climate justice field, I think that it's great when we win, but it's hard often to do so. But the very fact of the litigation being brought is educating judges and used as a kind of campaign tool itself by our brave clients. The other thing to say is that on the Gypsy and Traveller side of my my practice, I've had the privilege of working with a number of NGOs, and sometimes those NGOs come together and are able then to push their cause, in a much more coordinated and cohesive way, and also to influence politicians. And so NGOs play a really big part in activism outside of the courtroom. And on one or two occasions, we've managed to convince the politicians that in fact policies should be adopted, which do quite a lot of good in terms of facilitating the traditional way of life of gypsies and travellers. So, it's not a case of there never being an opportunity to influence politicians when it comes to gypsy and traveller rights, but it does help if there's a coordinated push, there's a coordinated effort amongst gypsy and traveller communities and their supportive NGOs. An effort to get the politicians to recognise the problem and then address it.
Well, I mean, Marc, you have provided us with fantastic and obvious opportunities of how activism works with litigation and achieving results, not only for the groups and the communities that you represent, but it's much more far-reaching than that. So thank you so much for sharing your work with us today. It's fascinating, and I look forward to hearing more from you in terms of your cases, and you've had a great success today. So congratulations on your recent work, and we hope to chat to you again.
Thanks very much, Sarah. It's been a delight.
Thanks everyone for joining me today. If you like the show, please remember to share and leave a review if you have a moment. And you can also check out our website, www.activistlawyer.com, where you will see some blog articles written by our guests and contributors, as well as some fabulous Activist Lawyer merchandise.
This podcast was recorded in Granite Podcast Studio. Interested in starting up your own podcast but don't know how? Granite Podcast Studio can help. Record your podcast in our state-of-the-art studio, which is based in the heart of Newry City. Our studio has cutting-edge and user-friendly technology and can seat up to 4 people. We also provide an editing service for our team, using your guidance and editing notes to provide you with a flawless finished product, leaving your listeners wanting more. For more information on how you can get started, visit www.granitepodcaststudio.com.